right now. This is the Amicus Curiae brief disclosing a military report on Covington and Burling Flynn motion. Comes now, Scott Bennett, petitioner, and files this Amicus Curiae brief disclosing a military report on Covington and Burling Flynn motion in response to Judge Emmett G. Sullivan's invitation for briefs to assist the court by 1, providing information, testimony, and insight that has bearing on the key issues in this case, 2, that this court is not presently aware of, and 3, that in the interest of justice must be considered for the following reasons. Number 1, Scott Bennett's information is material and relevant and must be considered because Mr. Bennett was a U.S. Army officer and counterterrorism contractor at the State Department with a top-secret, sensitive, compartmentalized information security clearance, whose work interfaced with Covington and Burling, General Michael Flynn, and Sidney Powell, as well as the Department of Justice, FBI, DIA, CIA, and other agencies at U.S. Central Command. All material is unclassified. See Exhibit 1, Credentials. Bennett's information will demonstrate that Covington and Burling had an egregious conflict of interest, and the law firm sought to protect its multinational clients and their governments by impeding and obstructing General Flynn and silencing him through a disingenuous plea deal to block the exposure of Covington and Burling's role in various Clinton, State Department, Obama administration, Justice Department pay-to-play schemes implemented through the Clinton Foundation, involving Middle East regimes and facilitated by the Union Bank of Switzerland. See Exhibit 2, report filed with Congressman Mark DeSaulnier for White House review and DOJ Inspector General investigation. And Exhibit 3, video interview of Bennett with Congressman DeSaulnier's office in 2016. That was the interview you and I did, Mike, when we went to Mark DeSaulnier's office. 3,
right.
In August 2016, Bennett met with and filed unclassified information and documents with Congressman Mark DeSaulnier, Democrat of California, and then later shared them with Sidney Powell and Joseph Flynn, General Flynn's brother, to alert and caution them about Covington and Burling's conflicts of interests concerning the law firm's representation of General Flynn and his apparent entrapment. This meeting between Bennett, Powell, and Flynn occurred when Bennett was a guest speaker at Operation Classified Conference in Dallas, Texas, in November of 2018, before General Flynn terminated Covington and Burling. See Exhibit 4, video of discussion with Sidney Powell and others about Covington and Burling conflict of interest. Summary. Mr. Bennett is a friend of the court, is a former U.S. Army Special Operations Officer and State Department counterterrorism analyst, and served as the liaison officer for U.S. Special Operations Command to the State Department's coordinator for counterterrorism, Ambassador Del L. Daley. Bennett, along with whistleblower Edward Snowden, was an associate at Booz Allen Hamilton, who also served as a terrorist threat finance analyst at U.S. Central Command under Dov S. Zakheim, father of Covington and Burling attorney Roger Zakheim, who worked at the House Armed Services Committee before his engagement by Covington and Burling. See Exhibit 5, Covington and Burling staff connected to Scott Bennett, General Michael Flynn, and Shellgate. Number 5. Bennett's mission was to analyze, identify, target, and destroy terrorist financing personnel and their networks, including banks, foundations, and law firms, and their related operations in the U.S. Central Command Theater of Operations. The Clinton Foundation and Obama administration utilized Covington and Burling and its client, Union Bank of Switzerland, to facilitate and finance mercenary recruitment, training, and deployment throughout the theater of operations, including the conflicts in Libya and Syria. See Exhibit 6, terrorist financing and money laundering connections to Swiss banks in Covington and Burling and Shellgate. Number 6, pursuant to 18 U.S. Code 2339A, providing material support to terrorists, Bennett's information will demonstrate 1, Covington and Burling may have engaged in acts and conduct providing material support to terrorists against the interests of the United States, and former Attorney General Eric Holder, and former Assistant Attorney General Lanny Breuer may have conspired with former and current Justice Department officials to ensnare General Flynn using sophisticated means, thereby violating the Justice Against Sponsors of Terrorism Act, S.2040, and 2, then confused and deceived this honorable court, violating 18 U.S. Code 2382, misprision of treason, And 3, undermined the legal defense and violated the constitutional rights of General Flynn, violating 18 U.S. Code 241 and 242 to conceal such acts and conduct in this proceeding. See Exhibit 7, Shell Game Report. Number 7, Bennett's information will demonstrate that Covington & Burling has collaborated with other parties to implement a multidimensional deception operation using sophisticated means against this honorable court and the Trump administration, and use the allegations against General Flynn as the cornerstone for their case about Russian collusion. Bennett's documentation will show that Covington & Burling's multinational clients and their governments relied on their legal staff to coordinate activities and thereby encouraged an abusive and malicious prosecution of General Flynn to cover up corrupt financial schemes related to terrorism and therefore represents an immediate threat to the national security of the United States. 9. For these reasons, Covington & Burling knowingly and intentionally disregarded this court's order to produce Mr. Flynn's successor, counsel Sidney Powell, all documents and communications concerning their prior representation. Covington & Burling then immediately engaged its contacts in the Justice Department to drop this case to avoid exposure of the prior communications between Covington, the Clinton Foundation, and the Obama Justice Department attorneys, specifically Eric Holder, Lanny Brewer, Michael Chertoff, and Roger Zakheim. A former employee of Covington & Burling will testify and confirm that its lawyers intentionally hid its numerous conflicts of interests, clients, staff, activities, to shelter claims of potential criminal and unethical conduct. General Flynn, as a former director of the Defense Intelligence Agency, did not know all clients and activities of Covington & Burling, especially UBS and its facilitation of terrorist financing. Covington & Burling failed to disclose material information to General Flynn, which was disclosed by Brad Birkenfeld privately to Mr. Bennett, who revealed such information to Sidney Powell and Joseph Flynn at the same conference. See Exhibit 4, video of discussion with Sidney Powell and others about Covington & Burling's conflict of interest. Incidentally, I'll put this up on the website, a new version of my conversation with Sidney Powell at shellgamewhistleblower.com. Department of Justice Deception Operations, Deep Black. 11. Scott Bennett, in his speech at the Operation Classified Conference, reported that while working at the Department of Justice, Covington & Burling attorneys Eric Holder, Lanny Brewer, and Loretta Lynch implemented Deep Black, a secret program in which inmates at federal correctional institutions were compelled to attend re-education classes to brainwash them into accepting global CIA, Israeli Mossad drug running operations and the assassinations of military and political officials opposed to them. The syllabus for this, quote, re-education, unquote, is attached as an exhibit, and Mr. Bennett witnessed the implementation of this program designed to indoctrinate prisoners in Oakland, California. See Exhibit 8, Deep Black, the DOJ Prisoner Program. The content of the Deep Black program was under the jurisdiction of Attorney General Eric Holder and Assistant Attorney General Lanny Brewer and the Department of Justice. The course materials are alarming and disturbing, and compulsory attendance constitutes a violation of the constitutional rights of inmates, 18 U.S. Code 242, 42 U.S. Code 1985. The program of Deep Black constitutes waste, fraud, and abuse of taxpayer funds. This court is encouraged to refer this Deep Black program to the Inspector General for immediate investigation. Covington & Burling's terrorist financing clients. 13. Brad Birkenfeld, an American Swiss banker, identified 19,000 Union Bank of Switzerland accounts involved to some degree or another in terrorist financing. Covington & Burling represented Union Bank of Switzerland. The accounts involved Saudi Arabia, Qatar, and other Sunni Wahhabi regimes, as well as terrorist financing networks. 14. Mr. Birkenfeld, over a period of 6 months, provided Mr. Bennett with various documents, bank accounts, and WikiLeaks cables that clearly proved the Clinton State Department and Clinton Foundation and the Department of Justice under Eric Holder were committing crimes against the United States with support from the Obama administration. See Exhibit 9, WikiLeaks Cables Report. 15. Birkenfeld also reported to Bennett, among many other things, that because Birkenfeld had been the personal banker of Russian oligarch Igor Lenikov and terrorist financier Abdullah Aziz, He had been specifically targeted between the years 2005 to 2009 by the CIA, FBI Counterterrorism Task Force, and the Department of Justice. Interestingly, Mr. Bennett's colleague Edward Snowden had been the CIA agent who maneuvered Birkenfeld into a false DUI incident and later reported this event in Snowden's interview with Glenn Greenwald of The Guardian. This court need only consider the controversies involving Brad Birkenfeld, Edward Snowden, and Julian Assange. They are all interrelated. See Exhibit 10, UBS terrorist financing account given by Brad Birkenfeld. 16. Birkenfeld shared with Bennett the fact that Covington and Burling's prior lawyers, Eric Holder and Lanny Brewer, were using their positions in the Department of Justice to direct Loretta Lynch to protect Covington and Burling's client, Union Bank of Switzerland. With the assistance of Brad Birkenfeld's boss, Robert Wolf, chairman of the Americas for UBS Wealth Management, Eric Holder directed Loretta Lynch to give UBS a 2% fine and non-prosecution agreement for crimes it had committed in exchange for financial donations to the Clinton Foundation and the imprisonment of Brad Birkenfeld. Eric Holder justified this crime by redefining it as, quote, banks are too big to jail, unquote. In reality, Eric Holder and Lanny Brewer were acting on behalf of themselves and their former employer, Covington and Burling, by protecting its most valuable client and securing for themselves future positions at the firm, which they indeed took immediately after leaving the Obama Justice Department. See Exhibit 2, report filed with Congressman Mark DeSaulnier for White House review and DOJ Inspector General investigation. Bennett's information will demonstrate that Secretary of State Hillary Clinton and her staff worked with Covington and Burling's attorney Stuart Eizenstat, the Clinton Foundation attorney Jenny Rhee, who later joined the Mueller investigation team without disclosing this conflict of interest, and other members of the Obama administration on various pay-to-play scams and secret deals. An example of this was Switzerland's agreeing to relocate Chinese Uyghur terrorists from Guantanamo Bay, Cuba to Switzerland in exchange for concealing the UBS Covington-Birkenfeld matter. Robert Kellner, Flynn's attorney, also specialized in pay-to-play operations. Bennett confirmed this from his work at the State Department's Coordinator for Counterterrorism, see Exhibit 9, WikiLeaks State Department Cables Report. 18. Bennett, upon discovery, recognized the financial corruption and dangerous national security implications of this relationship involving Covington and Burling, Union Bank of Switzerland, the Clinton Foundation, and the State Department and Department of Justice, and filed a report disclosing this entitled Shell Game, a military whistleblowing report to Congress. See Exhibit 7, Shell Game Report. Bennett, as a military officer, was bound by his oath to protect the Constitution against all enemies, foreign and domestic, and thus obligated under law to report these matters. Consequently, Bennett filed his report Shell Game with the Inspector General at the Department of Defense, Lynn Halbrooks, and mailed copies of it to the following military and government agencies: U.S. Civil Affairs Psychological Operations Command, General Jeff Jacobs and Lieutenant Colonel Bauckham Fulk; U.S. Central Command, James Mattis; Army Attorney Avi Stone, the Defense Intelligence Agency, and numerous committees and members of Congress. The Shell Game Report directly implicates the following government agencies and persons in criminal racketeering and other crimes: former President Barack Hussein Obama, State Department Secretary of State Hillary Clinton, and the State Department Coordinator for Counterterrorism; Central Intelligence Agency Director John Brennan, Department of Treasury Terrorist Finance, former Secretary Tim Geithner; U.S. Central Command, Terrorist Financing, MacDill Air Force Base; Department of Justice, former Attorney General Eric Holder, Assistant Attorney General Lanny Brewer, Attorney General Loretta Lynch; former Clinton Foundation attorney and member of the Robert Mueller investigation team, Jenny Rhee; Clinton Foundation President Donna Shalala and her nephew, David Shalala; Leon Panetta, former SecDef and Booz Allen Hamilton executive; James Clapper, former Director of National Intelligence and Booz Allen Hamilton executive. Others not listed here for the sake of space. See Exhibit 11, partial list of recipients. 21. Covington and Burling hired Roger Zakheim, former legal counsel at the House Armed Services Committee, as an attorney in exchange for Roger Zakheim's suppression of Bennett's military terrorist financing report, Shell Game. In fact, Shell Game was sent to the House Armed Services Committee and reviewed by Roger Zakheim. The report exposed contractor fraud and other crimes by Dov Zakheim, Roger Zakheim's father, and Bennett's supervisor at Booz Allen Hamilton. Military personnel were killed and wounded as a result of the Zachheim's suppression of Bennett's shell game report. In a related matter, State Senator Dick Black, Republican of Virginia, reported to Mr. Bennett that in 2016, FBI Director Andrew McCabe sent 4 FBI agents to his office to entice him into traveling to Syria to initiate negotiations with the Assad regime over the release of a journalist. At the time, Andrew McCabe's wife, Jill McCabe, was substituted in as a candidate against Senator Black with encouragement from the DNC chair, Terry McAuliffe, and candidate Hillary Clinton. The cover-up is worse than the crime. Let's see. Soon after receiving Bennett's shell game report, Senator Dianne Feinstein, chair of the Senate Intelligence Committee, and Senator Bill Nelson communicated about Scott Bennett and Edward Snowden in a private letter dated June 20th, 2013, condemning Bennett's report and recommending prosecution for filing it. See Exhibit 12, letter between Senators Feinstein and Nelson about Bennett's report. By ignoring Bennett's materials and refusing to investigate, Senator Feinstein and Senator Nelson may have contributed to the aiding and abetting of terrorist financing, see 18 U.S. Code 2339A, terrorist financing, and 18 U.S. Code 2382. Soon after Senators Feinstein and Nelson discussed Bennett's shell game report, journalists Michael Isikoff, NBC News, and Tom Hamburger, Washington Post, contacted Mr. Bennett and requested a private interview. Bennett agreed and debriefed them on the shell game materials and gave them the documents. See Exhibit 13, letter to Mr. Bennett. This concludes today's broadcast, Mike. We'll pick it up next week and continue reading the motion, but all...
Yeah, no place to run, no place to hide. Bye-bye.